Welcome to the Probate Nation. My name is Richard Ruddy and I'm the host of the program this evening. When someone passes away, probate of an estate is the process to transfer the title or ownership of probate assets to the beneficiary of the decedent. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiary. Some probate train rides are short, while other probates seem to never end. Our program today focuses on some common probate avoidance techniques that turn what would be probate assets that go on the probate train ride and convert them into non-probate assets that pass outside of probate and thus avoid the time and expense of a probate journey. Each of these techniques has advantages and disadvantages, which our guests will explain in the course of the show. Our first guest is an attorney with the Tyson's Corner Law Firm of Smolin Plevy. His practice areas include succession planning for businesses, general corporate law, estate planning, and state administration. He is a member of the bar in Virginia, Maryland, and D.C., and is a licensed certified public accountant. He is a frequent lecturer on succession planning and tax planning for businesses and estate planning for individuals, and argued a precedent-setting estate administration case before the United States Supreme Court. Our second guest is an attorney with the Cummins Law Group in Fairfax. He limits his practice to wills, trusts, and estates. He is a graduate of Amherst College and received his law degree from the Columbus School of Law at Catholic University in Washington, D.C. He is a member of the Virginia and D.C. bars and has been in private practice for over 40 years. Please welcome attorneys Dan Ruttenberg and John Cummins. Gentlemen, thanks for joining us.
You're welcome.
Thanks for having me.
Oh, it's a pleasure. All this brain power on one show. It's fantastic. Well, John, let's get started with some of the very basic, probate avoidance techniques. We call these the joint account. What is a joint account?
Joint account is typically a bank account, although there could be an account at a credit union or other financial institution. I'm going to talk, at least initially, about bank accounts and credit union accounts. That's where two or more people have an interest in the account.
Okay. How does a joint account avoid probate?
In Virginia, and it's important to point out that the rules in different jurisdictions are different in many cases than they are in Virginia. So if you have a joint bank account in Virginia, and at the time you opened the account, you selected rights of survivorship, very important feature. It's a check the box type of thing. You selected rights of survivorship. Then when the first or the initial owner dies, then the two remaining owners automatically take the property. It's said to pass to them by operation of law.
Okay. And of course, the benefit of a joint account is that it doesn't go through probate. What's the downside of a joint account, though?
The downside of the joint account comes from the failure of the person who controls the joint account to begin with to coordinate that joint accountness with his other or her other probate plan. So that if, for example, I am opening up a joint account with my niece who assists me in taking care of my bills and so on, and I put her on the joint account, and there's a large balance in that account, and I die, it may not have been my intent that my niece take the remaining money in that account. In other words, I have a different estate plan with respect to what happens to my wealth when I die. So I've failed to coordinate. That's a big risk with joint accounts. So coordination is important.
And we're going to follow that theme throughout all of these various probate avoidance techniques to stress that importance. Dan, let's turn to real estate. Okay, so can real estate be owned jointly?
So in Virginia, for real estate, there's basically three ways that two people can own property. They can own it as tenants in common. And that means your half of that real estate goes by way of your will.
Okay.
You can own it jointly with rights of survivorship, which means it goes to the last person standing. And then married couples can own something called tenants by the entireties, not to be confused with tenants in common. And that works very much like joints with rights of survivorship, but there are two main differences. One, you both have to agree to change it. But two, and I think more importantly, there is a creditor protection associated with that. meaning that in order for someone to go after your house, they have to have a claim against both of you. If they only have a claim against one of you, they can't go after your house.
And that's important. That's very important. And that actually is so important that it actually has been statutorily enacted to allow that to follow its way into some of the revocable trusts we talked about as well.
It does. It does. We can go down that rabbit hole if you like.
We'll view that a little more further down.
And one thing I would add, Richard, is that it's important to figure that out at the time when the house is originally purchased, because that's where that tenancy by the entirety or joint tenants, that's when that becomes relevant on the deed.
Okay, good point, good point. So what's the downside to owning real estate jointly?
Well, the downside of owning real estate jointly can be very similar to what you have with the joint accounts. So one, it may or may not go where you intended it. And two, you're also potentially, if you're doing this with your children, as opposed to with spouses, you potentially are subjecting your real estate to your children's creditors. So you don't want your house being involved in a divorce, your children's divorce.
Very good point, very good point. Well, John, let's turn to another topic that we use frequently, or we see a lot. That's called POD and TOD accounts. So we all get these acronyms that float around. So tell us what POD and TOD means.
POD is short for pay on death or payable on death.
Okay.
TOD, very similar, short for transfer on death.
Okay.
There are some jurisdictions locally, like Maryland, we're not going to go in there too much, but sometimes you see a TOD account in Maryland that's a trust on death, something different. We can talk about that at a different time. But POD accounts and TOD accounts in Virginia, it also is important as to who holds those accounts. Banks and credit unions. The decedent's portion of the TOD account is subject to claims of his creditors on death and has to be accounted for in the probate administration process, at least in part. Whereas a POD or a TOD account at a brokerage house or a non-bank or non-credit union, generally speaking, does not have to be accounted for in the probate process.
Okay, good to know. And the downside, of course, with the POD and TOD accounts are?
This is going to get repetitive, but once again, it's important to coordinate the POD account and TOD account with the overall estate plan. It's different primarily from a joint account, it meaning a POD account, as compared to a joint account. A POD account, the original owner of the money that created the POD account doesn't give up interest in that money while he or she still lives. Whereas in a joint account, depending upon a lot of different factors, the joint account owner also may have an interest in that money while the original owner still lives. Big difference.
And that leads to the creditors going to have access to that money, whereas a POD or TOD, they do not get access to that money.
Correct.
That's important. Dan, let's talk about life insurance beneficiary. Everybody seems to have life insurance, especially a lot of young folks, which of course we recommend they get that. Who are the beneficiaries of a life insurance policy? Who are the typical beneficiaries, and how does that?
Just in basic, the way you control generally where the death benefit goes on a policy is with this beneficiary designation. The beneficiary designation can be anyone. It can be a charity, can be your children, can be your spouse, could be me, can be anyone you want.
And typically you generally designate that beneficiary, at least at the outset when you're filling out your application, and you fill out some person's name or institution or whatever.
Right. They have a form, and often that's when that's filled out, although not all the time. And if you wanted to change it, it's very easy to change. You get a form. Often they're online these days, and you can just fill out who that beneficiary is.
And how does one go, and so that we get that, how do we designate someone as a beneficiary? How do those proceeds avoid probate?
So there's probate assets and there's non-probate assets, and the non-probate assets are really ones that have instructions built into them, okay? So a beneficiary designation, whether it's a payable on death or life insurance or retirement, is going to dictate where that money goes. And life insurance is often, especially for younger people, one of their largest assets. And what do and I'm probably getting ahead of one of your questions here. But who do young people designate for their beneficiaries? Their children, right? You want your children who are 3 years, 10 years, 18 years old to be the beneficiary of the life insurance. That's often why you're getting it, and God forbid something happens. And that can be very dangerous, because what happens in that situation is that money goes to those kids. This is one of the most common errors I see in estate planning for people that aren't doing it properly, is they might have some very protective provisions in their will where they want that money held in trust until the children are more appropriate. They don't want people getting money at age 18. Sudden wealth can be a disaster.
True.
And so they name these children as the beneficiaries, and those kids get at age 18. Very, very important that you keep your beneficiary designations up to date, and it is not a good idea to name young children as beneficiaries.
And if nobody is named as a beneficiary, or if whoever you've named as a beneficiary is not alive, and the default provisions don't allow it to go further on down the line, what happens if there's no beneficiary named in the life insurance policy?
Well, that's going to depend on the type of policy. So the Supreme Court case you mentioned was exactly on that. This was a federal employees group life insurance policy. So in that situation, what happens is there's a federal statute that dictates. Doesn't matter what anything else says. It doesn't matter what your state law says. That is going to go where it's going to go. So they've got an order of precedence. Servicemen's group life is very similar. But if you've got a private policy that you just bought, it's going to go by way of a contract. And the contracts can vary. And it could go to, it might say go to your closest relatives, and they might name who those relatives are. Or it might say go to your estate, in which case it's put it into probate. So what you thought was a non-probate asset by way of beneficiary designation has now been put into your estate by way of either naming the estate as the beneficiary or having that as the default rule.
Okay. Well, let's turn to the other major asset that we see nowadays that's also controlled, and that's the retirement account beneficiary designation. John, who are typically the beneficiaries of retirement accounts?
Once again, it's up to the so-called participant in the account. One thing to remember here is that in the stew of different rules and law we have, there's one particularly important law that is in the foundation of most, not all, but most of these issues, and that's a law that passed back in 1974 called ERISA, the Employment to Retirement Income Security Act of 1974.
You got it all out in one breath.
The importance of understanding that law for our purposes is that the rules under that law may be different than the rules that we've all been talking about and some of your other guests have been talking about with respect to what state law governs the passage of wealth upon death. So that when there's a conflict between that federal law and the state law, almost invariably, not always, but almost invariably, the federal law wins. And if the person who has the account is not aware of that, once again, you have this unintended consequence of something that was intended to be a simplifying feature.
Okay. How does one designate a beneficiary for a retirement plan?
Same process as there exists with respect to life insurance policies. Most custodians or administrators that manage the pension or the profit sharing or the 401k or the IRA money, because you can have IRAs in this mix as well.
Yes.
That's an individual retirement account. Most of those provide for a beneficiary designation form very, very similar. So it's a question of getting that form and filling it out correctly and consistently with your other plans on who gets your money when you die. One very important difference, and this is not true in all cases. There's something called a Roth IRA or a Roth portion of a 401k. That's not what I'm talking about. But virtually all of the other types of retirement accounts have an income tax burden that most life insurance doesn't have. So it's absolutely critical for the client to be able to be well advised and carefully advised by a competent professional. I would suggest a CPA or an attorney with experience and knowledge in the area, because a lot of us have enough knowledge to be dangerous in that area. I almost invariably refer it to an accountant who understands the rules, because the income tax rules are about as complex, as difficult to navigate as you can possibly imagine.
And for many people, the retirement plans as you get older become a huge portion of their estate.
Look at Northern Virginia, the typical couple in Northern Virginia who's been employed, or at least one of the couple been employed. You have equity built up in the home. You have some life insurance. But almost invariably, one of the biggest liquid assets that there is out there is the retirement account.
Indeed. And it's all growing tax-free, but there eventually is going to be a bill to be paid.
There's a day of reckoning, and there are many rules that enable the owner of the retirement account to stretch out the time over which you have to pay your income taxes. But those rules are complicated, and as I said, you need a competent professional to advise you of any of the area we're talking about today. That is probably the most pregnant with risk.
I couldn't agree with you more.
And the penalties of getting that wrong are draconian.
Right, which you have to have things come out at a certain time. If they don't come out, then you're going to run into all kind of, and they stack on top of each other and become very costly. Well, Dan, let's turn to lifetime and deathbed gifts, because that's another way in which we could, in theory, do some probate avoidance planning. Okay.
That's true.
So what is a gift?
Well, gift is when you give an asset to someone, your children, your spouse, anyone, charity.
Okay.
So the concept is simple.
And what's the benefit of giving the gift away?
Well, there's a lot of benefits to lifetime gifting. One, you can see your children enjoy and have that money during their life. So, it's not all about avoiding probate. It's not all about reducing your taxes. There's some enjoyment in that. There's other issues of you can get a tax benefit as well if you're subject to, let's say, an estate tax. And the estate tax laws, you have to worry about the federal government and the states, although in Virginia we no longer have an estate tax. Doesn't mean they're not going to bring it back. Doesn't mean you don't own real estate or you don't end up living in a jurisdiction that does. But you have to be aware of both of those situations. And if you have a high enough asset level, sometimes people will gift assets during their lifetime to reduce that estate tax. Also, if you don't own the asset at your death, and you've transferred it during lifetime, you have avoided the probate. If you give something to your children now, it's not going to be subject to that. And that is nice and clean and simple.
So what is the downside of giving away property during their lifetime?
So this is one of the big mistakes, amazingly costly mistakes that I've seen people do. Thankfully, I've been able to stop it at times, but deeds. And it can be any property, but this is I don't want to get too complicated here, but let's say you bought a share of Amazon for $50, and then you sold it for $1,000. So there are some people like that. If you sell that, you got to pay capital gains. And if you give that share of stock to your children during their lifetime and they turn around the next day and sell it, they have to pay capital gains. But if you hold on to that share and you die with it and you bequeath it to your children, they get what's called a step up in basis. They can turn around the next day and sell that share of stock without paying any gain at all. Now imagine this with your house. You're sitting there and you've got this $1 million house that you bought a long time ago for $100,000. And you, thinking you're being clever, transfer this on your deathbed to your children. So now your children, instead of if they had waited, a month and inherited it, they would have been able to sell that without any capital gains. But now because you gave them that house right before you died, they're going to have to pay $900,000 of capital gain in that example. It's horrific. And so deathbed transfers, generally speaking, do not accomplish what it is you're trying to do.
And just to put that in perspective for our viewers, the reason that that's become more relevant is because the amount of assets that you can die with has jumped dramatically. You can die with over $5.5 million approximately now and not pay any estate taxes. And so the planning now is really to hold those assets as long as you can to get that basis stepped up as high as you can to basically, and you have to begin to weigh the estate tax cost of holding it versus the capital gains tax of giving it away.
The analysis gets much more complicated now because the income tax component is much more relevant in the discussion. Sometimes estate tax planning is the right move, but if you're under $5.5 million in assets in total, now you also have to keep in mind we're talking about your real estate, your retirement accounts, your brokerage accounts, even the death benefit on your life insurance. Not everyone understands that that's included in that pile of everything. That can put you over that number. So someone's taxable estate they can easily be a millionaire or a $5 millionaire or whatever, whereas they certainly don't feel that way during life.
They don't. Yeah.
Dan, doesn't it also mean that with certain changes in the rules at the federal level now, a husband and wife can pass to the next generation twice that $5.5 million or $11 million? So consequently, the number of individuals out there that are concerned about federal estate taxes as opposed to state estate taxes, you said Virginia doesn't have any, but DC and Maryland do, is substantially less than one would imagine.
Yeah, absolutely.
It definitely has come down. I think more of the planning now is, as you say, to worry about the income tax side at the end of the day, wipe out some of that income tax, and just do what you want to do as far as who you want to have the assets and how you want to give it to them, and do some planning about the rest of the life for your children and your beneficiaries.
And don't forget about charities. Charities are very important to gift to as well.
I'm available to be a charitable recipient.
And charities you can give to during your lifetime because they're tax exempt. They're not going to have that basis issue. Feel free to give to your charities during lifetime. And one of the best ways to do it, I'll just mention it, is with a retirement account that you talked about. Because when your children inherit the retirement accounts, they got to pay taxes on it, but the charity doesn't.
Good point. We're running short on time. We want two more areas, so we'll cover those briefly.
Okay.
John, let's talk about wills. Okay. Is there any type of will provision that can help? It can't eliminate probate, but it can help sort of short circuit some of the probate process?
Sure, but remember, when you're talking about a will, you're talking about the control of probate property. So if we are identifying and characterizing non-probate, there's very little a will can do. It's somewhat akin to closing the barn door after the horses have left. But in the will, we can put provisions to make the administration of the probate far easier, far more straightforward, and far less complicated when it comes to dealing with the local courts and with the quasi-judicial official who's designated to supervise administration. We call them the commissioners of accounts.
Okay, good. Let's turn to revocable trust, Dan. Okay, that's when we talked a little bit about, again, what is a revocable trust and how does it help us avoid probate?
Okay, so trusts, I like to analogize to a corporation. Everyone's familiar with a corporation. What is that? That's a fictitious entity that exists because the law says it does. Trust is very similar. Instead of officers and directors and shareholders, who are the parties to the corporation, parties to the trust are the trustee who administers it, the beneficiaries for whose benefit it's administered, and the grantor, that's who sets it up. And you have two types. You have what's referred to as a testamentary trust. That's one that you have in your will, and all the rules are spelled out, but you don't put any money in it. It's like giving assets to your kids until they're older. The other type of trust is a living trust, and that's one that you set up and put assets in while you, the grantor, are still alive. And in the living trust world, there's revocable and irrevocable, and like the name sound, revocable are very flexible. Take assets out, put them in, change the rules, do whatever you want.
Good. And the assets that are put in these trusts while you're living, and typically the revocable trust is the tool that many people use, those pass without going through probate.
Right. So an asset that you've taken, a probate asset that you put into a revocable trust, you've converted into a non-probate asset. I like to analogize it again. It's like a complex beneficiary designation. All the instructions are built in. If you die, your successor trustee steps in. They have full legal authority to distribute those assets in accordance with the trust. But keep this in mind, a lot of people set these up, but they don't put their assets in. If your assets are not in the trust, you're going through probate. You might have what's called a pour-over will, says I leave everything to the trust, but if that's doing anything, you're in probate, and the goal is to avoid probate.
Or may I add, that if you do set up the revocable trust and you, quote, put your assets in, unquote, and time goes by and you start developing other assets, you buy a new home, You put money in a different bank account. You have stocks and bonds. And those assets don't go into the revocable trust at that later date. Then you may end up with the necessity of having to have a probate estate as well as the revocable trust. So once again, coordination.
And of course, the need to review and update. Guys, this is a lot of information, and I know that we could talk for hours. You guys have got a lot of good stories, I'm sure, to share with our viewers. But let's go to some final thoughts about the whole process of probate avoidance and some of the advice you might give us, some sort of final points you might give to each of our viewers, to our many viewers.
Sure.
Dan?
So I think this theme is there throughout, but and what John was just really commenting on, it's important not just to do your estate planning, it's important to update your estate plan. It's not the type of thing you just do once and you're done with. You've got to update it. You might get divorced and have a bunch of beneficiary designations naming a former spouse. You might get more assets and need to put them into your trust. So the important final thought is not just to do it, but to keep it updated.
Okay. John, how about yourself?
Yeah, this is a process. This is something that has a beginning, it has a middle, and it has, unfortunately for all of us, it has an ending point, and that usually comes with the death of one of the two clients that you have. But if you don't look at it as a process, and you think that it's all done simply because I went to the lawyer and he drew the will and that was it, you're going to be sadly mistaken. It is a process. It's an ongoing process. I usually tell my clients, when it comes time to do your income taxes, spend a half an hour and go over your estate process planning and make sure that there hasn't been something in the past year that's really changed. Another child, a divorce, and so on, so that you can then update your plan when it's appropriate.
Those are all good points. I want to thank you guys for taking the time to come and visit with us, for sharing all this great information, and for this being part of this public service to the community of Northern Virginia. Thanks again for coming in.
You're entirely welcome.
My pleasure.
Avoiding probate is certainly a popular planning objective, both for lay folks and estate planning attorneys who advise them. But I take away from our program some key points I encourage you to keep in mind. First, these probate avoiding techniques are just tools that have to be used carefully and in the context of an overall estate plan. Second, there really is no one technique that's appropriate for everyone to use, and many of the techniques can have unintended consequences that cannot be easily fixed after you have passed away. Third, it is critically important to review on a regular basis your overall estate plan. Consider what you have done and why in disposing of each of your assets, and confirm it still fits your situation. In closing, I strongly recommend that you work with a local trust and estate attorney to fashion an estate plan that reflects your wishes, coordinates the disposition of your assets, and in the course of that process, some of the probate avoiding techniques discussed in our show today will be appropriately used. In our experience, such professional advice on how best to structure and use any of the probate avoidance tools will be well worth the effort, and in the long run will best serve you and your loved ones. This brings us to the conclusion of our show. We hope you found it helpful. Replays of this show and all the shows broadcast today, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.